All right. Hello, everyone. I actually just did this lesson. I have to do it all over again because I realized only 3 minutes of it was taped because there was an internet difficulty. So, chapter nine again, very briefly. I'm going to teach it well though. Uh, Chapter nine is about eyewitness and scientific identifications. Identifications involve three procedures. Lineups. And of course, lineup is when a person's ball there physically, and you're lined up with a group of people, and a witness has to choose who was the person that did it, or whether anyone did it at all. Then you have show ups, and that's when you're usually out in the field at the scene when they've rounded people up and they have you sit down or stay there, and then they actually give the victim a car ride and ride them past where these people are, and they say, "Hey, was anyone in this group of people standing here? Is that who did it?" And the person kind of says it was this person, and then they can move. That's what we call a show up. And then you have photographic identification. So photographic identification is when you're not physically there or the defendant's not physically there, but their photograph is. So, identification is a crucial step in the criminal justice system that may lead to a suspect's being charged with a crime. The challenge is to ensure that the identification will be conducted in a reliable fashion. Physical identifications, lineups, and show ups are subject to constitutional limitations under the Sixth Amendment, right to counsel, and the Fifth and 14th Amendments due process clause. Photographic identifications are subject to limitation under the due process clause, and there is no right to the presence of an attorney at a photographic lineup. So that means you're not there physically, so you don't have the right to have an attorney there when people are looking at your picture. Wrongful convictions and eyewitness identification. Eyewitness identifications are like the number one cause of overturned convictions and or wrongful convictions that end up being overturned by better evidence that comes along later. That's why you have these cases with these guys who've now been in jail for 30 years. And of course, they're like, I didn't do it. I didn't do it. They're sitting in jail for 30 years. Then finally, the DNA evidence or DNA science comes along, and the case is reviewed, and they realize, wow, this person didn't do it. As a matter of fact, the DNA doesn't match, and it matches this person. Um, of course, that's why it is one of the leading, I guess, what do I say, causes of wrongful conviction. So identification is not a science and is not an exact process. Misidentifications are a leading cause of false convictions. There are three steps involved, in each of which involves the risk of error. You have perception. So perception means what your vantage point was, where you were. Was there something in your way to cause you not to see clearly? So you may be mistaken. That's perception. Then you have memory. In other words, it happened so long ago. Now you're in court and they're asking you to identify someone, or you're going to a lineup or a show up later on, and like, this the person that did it. You're like, dang, that happened a month ago. I don't know, but yeah, I think that's him. Then you have just identification itself. In other words, the person, and this is the part, especially when it comes to cross racial identification. Now, what I mean by cross racial identification, um, normally, as people of different races, of course, I'm an African American, a black man. That means I'm socialized most of the time with black people. When I go to a family event, I'm with my family a lot. I'm with other black people. That means I particularly know how black people look. I know that I look nothing like Denzel Washington. But when it comes to identifying people of a different race, whether it be Asian, white, um, Native American, or even Hispanic, I can't always, because I'm not socialized around those people. There's always a joke. All those people look alike. Sometimes to other races, you do. Um, so that means if someone from another race victimizes me in a crime, and now it's time for me to identify them in a room of people of the same race, I'm highly likely to mess that up. That's not a white thing. That's not a black thing. That's a people thing. It doesn't mean that white folks are just out here misidentifying black people. Black people are getting it wrong too. So cross racial identification is another leading cause of wrongful convictions. So sometimes you just misidentify a person. You may think that these two people look alike when in actuality they look nothing alike. Um, so the Sixth Amendment and eyewitness identifications. So man, in 1967, the United States Supreme Court in United States v. Wade and in Gilbert v. California, those two cases, they established that suspects have a Sixth Amendment right, constitutional right to a lawyer at all post-indictment lineups and physical confrontation. So indictment is, and the indictment is when you're officially charged with the crime and you're given notice. So you're indicted, the case is moved up to whatever the trial court is. And this is, of course, just on the federal side. So once you're indicted, there's going to be any further lineups. You have a right to have an attorney there. Absent the presence of a lawyer or waiver of a lawyer, a prosecutor may not introduce the results of a post indictment identification at trial. The prosecutor may ask a witness for an in court identification in those instances in which the lineup was conducted in violation of the Sixth Amendment. The prosecution is required to establish by clear and convincing evidence that the in court identification is not the product of a tainted identification procedure. So, of course, in court, they can always say, hey, point to the person that did it while they're in court or while you're on the stand, and they point. Um, the number one problem with that is the fact that a lot of times people identify people in court not necessarily because they're linking that person to what happened to them the night before, but it's really because this is the person that they've been seeing because they've been coming to all the court dates. They've been sitting in court with this person all day or however long, and they're like, well, that's John Doe over there. That's the one they say he did. They're saying that's the one who did it. So when it now comes time to point out the person who did it to you, this person now you're pointing out that person, but not because you remember them from that night, but because you've now been in front of them and you've been exposed to them at trial or in court. So you now know them because of that, but you're not pointing them out because you're linking them to the crime, but only because you know them from seeing them in court. There's a big difference. There's not really an identification. It's like, oh, it is Johnny, because I know Johnny now. So um, let's see. Okay, appearance in a lineup or show up is not testimonial evidence, but it is still protected under the Fifth Amendment right against self-incrimination. So that means you have the right. So let me read it again. Appearance in a lineup or show up is not testimonial evidence protected under the Fifth Amendment right to self-incrimination. So what that means is you can't say I'm not going to the lineup because I might incriminate myself. So you have to go, but you still protected. So the Sixth Amendment now applies to it. So it's not testimonial, meaning you're not saying anything. You're just essentially standing there. The Sixth Amendment right to counsel is applicable at all critical stages of the criminal process. Critical stages are those procedures between arraignment, and that's when you're asked if you plead guilty or not guilty, um, and trial. Of course, that's when you're at trial. In which and now and the critical phases are all stages between those two critical phases in which failure to provide a defendant with a lawyer may prevent a fair trial or may cause an unfair trial. The post arraignment lineup or show up, according to the majority of the Supreme Court, is a critical stage because individuals in police lineups or show ups who are unrepresented by a lawyer are at a high risk of being falsely identified as the perpetrators of criminal acts. Absent the pressure of a defense lawyer, the Supreme Court observed an individual. I'm sorry, absent the presence, not pressure, presence of a defense lawyer, the Supreme Court observed the individuals who conducted a lineup could not be subjected um, to effective cross examination concerning the composition or conduct of the lineup. So, in other words, if your lawyer's not there, they can't now in court when it's time to question how the lineup was conducted. The fact you don't have a lawyer there at the lineup means that now they can't really cross examine uh, the alleged victim or the person that's saying you did it or pointed you out in the lineup. So, just based upon the fact that you didn't have the opportunity to have a lawyer there to represent you at the show up or lineup, means that now you're pretty much kind of hamstrung, and you're kind of your case is injured because now you can't really challenge the lineup itself. So that's why it's very important to have a lawyer there, and that's why they give them that Sixth Amendment right at that part. Um, the Sixth Amendment and pre-arraignment identification. So this is before a person is arraigned or brought to court and asked whether they're guilty or not guilty or how they plead. In 1972, in Kirby v. Illinois, the Supreme Court concluded that a show up after arrest, but before the initiation of any adversarial proceedings, um, unlike the post-indictment confrontation in Wade and Gilbert, is not a critical stage of the criminal prosecutions at which the accused is entitled to counsel. But of course, you're arrested, so if they're going to bring you in the lineup, you may want to ask for counsel. That still doesn't mean that the Sixth Amendment and the due process, that doesn't mean that those things don't apply. Those rules still apply. So it still has to be fair. Um, Sixth Amendment and photographic displays. Now, photographic displays are different between lineups and show ups because of the lineup. You're physically there as a possible defendant, someone that the witness is going to possibly point out. So you're there. With the photographic lineup, you're not there, but your photo is. In 1973, in United States v. Ash, the Supreme Court held that the Sixth Amendment does not entitle the accused to the presence of a lawyer at a post-indictment photographic display containing his or her photos. So the lawyer doesn't get to be there, but there are rules that apply. So in other words, when they're doing the photographic lineup, they have to document the photos they use and how they use them in the double blind test and stuff of that nature to make sure that the court knows what they did, and so it can at least be tested or cross-examined. The due process test. On the same day that the Supreme Court decided Wade and Gilbert, the court in Stovall v. Deno established a Fifth and 14th Amendment due process test for the admission of the results of identification procedures. The judge is charged with the responsibility for determining by a totality of the circumstances, which you hear again, whether the confrontation, or that means the lineup, for whether it be photographed or whatever, was so unnecessarily suggestive and conducive to irreparable mistaken identification that the defendant is denied due process of law. So, in other words, if the lineup or however they do the lineup is so unnecessarily or overbearingly suggestive, meaning that the lineup and the way it's done isn't fair, and they're doing it to point at a specific person as opposed to giving the identifier the opportunity to choose from a wide variety of people, then that means it's unfair, and it's violative of your due process right. Now, let's talk about suggestiveness, reliability, and the totality of the circumstances. In 1977, in Manson v. Braithwaite, the Supreme Court fully developed the due process test for the admissibility of the result of identifications. The Supreme Court adopted a totality of the circumstances test in which the defendant must demonstrate. So now, I'm reading this carefully, in which the defendant has the burden of demonstrating that the procedure was suggestive. Now, once the defendant brings it up and says it was suggestive, then the burden shifts. It shifts to the prosecution to now demonstrate that the procedure actually was reliable. So they have to defend themselves, meaning that the result could be trusted. So the defendant has the obligation, if they feel like an identification was unfair or suggestive, they have to bring it up. So in other words, uh, there's no presumption that it's unfair unless you bring it up. So once the defense brings it up, then the prosecutor has the burden of proving that whether it be photo identification, in person lineup, or show up, or some other scientific means of identification. Once the defense says that we don't think it's fair or something's wrong, then of course the prosecution now has the burden of showing that it actually is correct and it's reliable. In Neal v. Biggers, the Supreme Court affirmed that the standard for admitting an in-court identification in light of suggestive identification procedures is whether there is a very substantial likelihood of irreparable misidentification. The question is whether the totality of the circumstances indicate that the identification at the show up is reliable. Now, let's talk about what different states say about identifications. In Massachusetts, the Massachusetts Supreme Court and the New York Court of Appeals have held that the due process clauses of their state constitutions actually provide for greater protection than the due process clause of of the U.S. Constitution, and require a per se or automatic exclusion of unduly suggestive identifications from evidence, however reliable. So if there's any inkling of evidence that this identification is unfair or overly suggestive, at least in Massachusetts and New York, it goes out. So we're not even thinking about using this identification. Now, scientific identification. That means these are identifications that are not based on a person identifying you or saying it was him or her based upon what they see, but it's based upon science. So something that's left at the scene that links a person or allegedly links a person to the crime scene or to the crime itself. The traditional test for the admissibility of scientific evidence was articulated in 1923, a long time ago, in the United States case. Now, we call so anytime you hear say the Fry case or the Fry test, we're talking about will refer to that case. The Fry test asks or the test that was applied in the Fry case ask whether a scientific technique is sufficiently established to have gained general acceptance in a particular field in which it belongs. So the Fry test, in order for scientific evidence to get in a trial, um, the whoever's entering the evidence must first establish that whatever it is that the science is connected to the evidence is actually generally accepted in academia or within the scientific community. So in other words, that meant no junk science got in, and really a lot of stuff didn't get in because science, of course, is limited. Um, so of course that was a very tight hole, tight kind of. You had to really thread the needle to get science in uh, when you applied the Fry test. So of course, later on, the United States Supreme Court developed an alternative or tested overturned Fry um, for the federal courts in the Daubert v. Merrill Dow Pharmaceutical. We call it the Daubert case and the Daubert test. So anytime you hear us talking about Daubert or the Daubert test, we're talking about that test that actually overturned the Fry test. So the Fry test is no longer the law. Now, I guess it can be adopted in certain places, but it's no longer the law on the federal side. Now we talk about the Daubert test. The Darbour test takes a broader view than the Fry and holds that scientific evidence is required to be both relevant, meaning it has to be have something to do with it has to be relevant to the case, and reliable. So, in other words, is it relevant and is it reliable? And is not limited to scientific techniques that are generally accepted by the scientific community. So under the Daubert standard, now anything that is relevant to the case, as long as there's an expert that can come in and say why it's relevant and say why they're an expert, it can come in. So um, uh, if it's a cosmetologist, if we're talking about a hair strand and what type of chemicals were in the hair strand that they found, and they want to figure out, well, why is this hair here, or is this fake hair, or was this hair permed a certain way? Let's say they have a cosmetologist come in and say, well, based upon the science of perming, of putting relaxers in and doing hair, I can definitively say, based upon my experience, now that means now I'm an expert, I can say that this was this type of hair. Now, of course, that's just an example, but the scientific community wouldn't probably, biologists or astrophysicists probably wouldn't recognize a woman that does hair and does weave as a person that's a scientist. So under the Fry standard, it wouldn't get in. But under the Daubert standard, it does get to come in if it's relevant and it helps us prove guilt or innocence in a case. Um, so you see how the tests differ. Fry was very narrow. In other words, the scientific community had to accept it for it to get in, and that means accept the whole science of what you're trying to get in, as opposed to the Daubert test saying, you know what, anything can get in as long as it's relevant and reliable. And that means you have to show that the person giving the testimony is reliable, knows what they're talking about, and they are an expert. Um, Next, we have DNA evidence. DNA, or deoxyribonucleic acid, as it's called, is a molecule that stores an individual's genetic code. Each individual has a distinct genetic code, um, It has a distinct genetic code. DNA may be used to include or exclude an individual as a suspect during a police investigation. So even DNA evidence isn't perfect. It's more of an inclusive or exclusive. It can say this person didn't do it, or it can say this person, within a certain degree of certainty, might have been could be included as someone that might have done it based upon probability. So state and federal courts, almost without exception, have admitted DNA evidence. It's pretty much the most reliable evidence we have out there. DNA evidence has been excluded when the DNA sample has been contaminated or the evidence indicates that there has been a failure to follow accepted procedures in gathering the evidence and testing the evidence. So I don't want you to think that DNA evidence is perfect just because it comes in. It can be challenged. It can be challenged based upon how it's tested, whether or not it's contaminated, and what we call chain of custody. So anytime evidence is lifted from a scene, there's something called a chain of custody. That means everyone that had that took a part in finding the evidence, pulling the evidence from the crime scene, has to write their name down and say, "I was the fifth person that pulled it from the evidence, or pulled it from the scene and took it to the evidence locker and did whatever." So if there's ever a break in that, and we don't know who had it from between this time and this time, um, or who checked it out, that means it could be subject to being contaminated. And that means now it's not necessarily about the DNA itself, but it's about how it was handled that makes it unreliable. So DNA can't be challenged. Um, okay, the DNA Analysis Backlog Elimination Act provides that persons convicted of certain federal crimes who are incarcerated or who are on parole, probation, or supervision must provide federal authorities with a tissue, fluid, or other bodily sample. So they got to provide a sample on which a DNA analysis can be performed. In North Carolina, actually, when you're convicted of a felony, they actually order that you go to the sheriff's office in that jurisdiction and actually give a DNA sample. Now we have polygraph evidence. Polygraph, a lie detector, is a form of scientific identification. The test measures an individual's physiological reactions to questions asked by a trained examiner. So, physiological means like blood pressure, perspiration, and respiration and heart rate. But it essentially tests their body's reaction to certain questions to determine whether it's a lie or not. The examiner evaluates the suspect's answers, whether the answers are truthful or untruthful based on the body's reaction. So, of course, if your blood pressure goes up or your heart rate goes up or perspiration goes up when you give an answer to a question, of course, they determine that your answer is a lie. The polygraph is not generally considered admissible into evidence because it really is, of course, is unreliable. So, and there are actually people that can beat the polygraph test. They can and tell lies the whole time and be just completely cool. So it's more a test to test nerves than it is a test to test your truthfulness or whether you're telling the truth. The lie detector test is not generally accepted by either of the scientific tests. Fry wouldn't have accepted it as science, and the Darber test wouldn't accept it as being reliable. So polygraph evidence is out. One of the types of identifying sciences that we left out today that is not in the book is fingerprint evidence. Fingerprint evidence is generally seen as being reliable under the Darber test, but it's not a perfect science. So if you watch these shows, CSI Miami or whatever, you always see them take a fingerprint, and they take it back to the lab and they test it and they run it and cross references and they say, "Bing, it's a match." That is not how fingerprint evidence goes at all. What happens, you have two types of fingerprints. You have a latent. A latent is your sample that you give, a controlled sample. When a person goes in, like me, myself, I'm a lawyer, so by virtue of being a licensed attorney in North Carolina, I have to, before I took the bar exam, I had to go press all of my fingers in dye and roll and give samples of my fingerprint. That is a latent. It's a full roll of the full finger. So we have the full finger. Now you have late. That's what we call a late. What happens is they match what we call partials to latents. A partial is a fingerprint that is partial. It's just that. So at a crime scene, normally you're not going to find a perfect fingerprint. When you think about when you touch things throughout the day, are you touching it perfectly with your hand so you can leave a fingerprint. You're not doing that. So what happens is they lift fingerprints from a crime scene. They lift partials. They usually lift things that aren't a perfect fingerprint. Here and there, they'll get lucky to be a whole fingerprint. And then a lot of times they even say they know what finger it came from. Well, that's a thumbprint. How do you know? You don't know whose hand it came from. My thumb, which is the widest and biggest finger on my hand, um, may be the size of a finger on Kawhi Leonard's hand. He has huge hands. He's in the NBA. Big. He can palm a basketball, big old hands. So my little thumb might just be the same as his index finger. So if you find a lift a print from the scene, I just want to know because I've been in trials where they say, yeah, it was a thumbprint. I'm like, how do you know that? Tell me how you know. Please explain. I want to know this. So fingerprint evidence is not perfect. As a matter of fact, the FBI actually botched the case about 10 or 15 years ago. It was a Spanish bombing case where there was a serial bomber that was bombing people in Spain. He was kind of a terrorist. And they lifted a fingerprint and actually got it wrong. They actually arrested the wrong person. So the FBI is like the foremost investigative body, and definitely in America, if not the world. And they made a mistake. So that goes to show the fingerprint evidence in and of itself is not perfect, but the court does allow it based upon the Dahlberg reliability test, so they allow it in. But it can be challenged. Like all this stuff can be challenged. It's harder to challenge DNA, of course, than it would be to challenge the lie detector, which isn't admissible anyway, or fingerprint evidence. But hopefully, you have an idea of eyewitness and scientific identifications and how that stuff works and the rules that apply. So we're always talking about either the Sixth Amendment right to counsel or the Fifth Amendment and 14th Amendment due process. So a due process clause. In other words, is the sample fairly tested? So even with fingerprint evidence and DNA evidence, sometimes that stuff can be unfairly, I guess, suggestive. So sometimes cops can get to a crime scene and say, we believe Boyce did it. So because we believe Boyce did it, any evidence we pull from the scene, instead of testing the evidence against a wide variety of possible defendants, we're just going to test it against Boyce. In some situations, they say we're just going to make it work and kind of match it to Boyce. So they get a fingerprint, and the way fingerprints actually work is what they do is they take different points on whatever the latent is and see how many points match points on a partial, and they see how many points match a latent. So they're trying their best to see how many points are the same on this finger as they are on that finger. And of course, the general scientific, what they generally say, what's generally accepted is no one has the same fingerprints. But really, they don't know that because they haven't tested everybody's fingerprints. They haven't tested. They haven't tested the fingerprints of everyone that's dead and no longer here. And they haven't tested the fingerprints of everyone that's living now. So we really don't know if everyone. Someone might have the same fingerprints as me. But I will never know that. So the thing about these sciences, and sometimes I call it junk science, is the fact that they haven't tested everyone, so they don't know. Um, so, um, uh, so of course, even with fingerprint evidence, it can still be overly suggestive. So that concludes chapter 9. I think I recorded the whole thing this time. I hope I did. So it'll be posted. Of course, I'm going to do 10 and 11. All these will be posted tonight. So you take care. Bye.